Hello, everyone, and welcome to Uncivil Law. For today's case, we have a case from the Supreme Court of the state of Iowa. This is State of Iowa versus Juan Salcedo. In this case, Juan was pulled over for a traffic violation, but evidence suggests the police were not really interested in the traffic violation. Instead, the traffic pull was merely a pretense to search for drugs, and drugs were indeed found. 80 pounds of marijuana were found in this car. And he has moved to suppress this evidence because it was illegally obtained by the police. So what does the Supreme Court of Iowa have to say about this traffic stop and arrest? And will the drugs be admitted against him? Let's find out. The defendant was stopped for violating Iowa code. The law provides that any vehicle proceeding at less than the normal speed of traffic at the time and place under conditions then existing shall be driven in the right-hand lane then available for traffic upon the roadways. In other words, if you're in the left-hand most lane and you're driving less than normal traffic, get over. Get over if you're in the left-hand most lane and traffic is passing you. Get into the right-hand lane. So, yeah. Deputy Sheriff Cody Hare of the Johnson County Sheriff Office was traveling eastbound on Interstate 80 in response to a reported reckless driver. While en route to the call, he encountered a different car traveling in the left lane of Interstate 80's two eastbound lanes. Deputy O'Hare's attention was drawn to this car because, despite the deputy's approach, the car did not move to the right-hand lane to let him pass. The posted speed limit on this stretch of interstate was 70 miles per hour. The deputy was traveling at 75 miles an hour in response to a dispatch call. He estimated the car was traveling approximately 60 miles per hour in the 70 mile an hour zone. So this is a guy traveling in the left-hand most lane of an interstate going 60 in a 70, even though traffic would not warrant this. So, this is someone that a lot of us hate for traveling in the left-hand most lane going slow, but that's not the issue. Let's press on. The car remained in the left-hand most lane throughout the duration, even when interstate became a 3-lane road. So when it moved from 2 to 3 lanes, he still was in the left-hand most lane, going 60, not 70, which was allowed. So, again, perhaps a picture of hatred to many of us. Deputy O'Hare switched back to the leftmost lane, followed the car for a moment, and then initiated a traffic stop. Then the car complied without difficulty. He explained he initiated the stop for driving too slow in the left-hand lane and asked the driver for his license and rental car agreement. Due to the loud interstate traffic and the cold November weather, Deputy O'Hare asked the driver to accompany him back to the patrol car. The driver indicated he had no weapons on him and allowed O'Hare to conduct a pat-down search when requested to do so. The driver identified himself as Juan Salcedo. Deputy O'Hare initiated a conversation with him and asked him about his travel plans. He explained that he was traveling back from California after visiting his girlfriend. Deputy O'Hare repeatedly thumbed through the rental car agreement. In response to questioning about the reason for the stop, Deputy O'Hare stated there was no reason for him to be driving in the fast lane. The conversation continued while Deputy O'Hare again quickly and repeatedly flipped through the rental car agreement. It appeared, based on body camera footage, that Deputy O'Hare put no effort into the process of the traffic interaction. So it looks here like he's purposefully slowing the stop, and that's not allowed under Supreme Court precedent. He has to take as much time as it takes. He cannot deliberately slow or extend the time of the interaction, so this looks improper. Within 7 minutes of him being pulled over, another patrol car arrived, and Deputy O'Hare exited his car to speak with the deputy Lenz. The suspect remained in the front seat of the car. Deputy O'Hare's body camera leaves no doubt he was quite disappointed to learn a drug dog was not available. Again, extending the stop so a drug dog can come is explicitly unconstitutional. The Supreme Court has ruled on this. You can't do this. If a drug dog just happens to be available, then so be it. But you can't extend the stop to allow for a drug dog to come. It looks like he was thumbing through the paperwork, not in an effort to understand it, but in an effort to delay so there'd be time for a drug dog to come. So he was not behaving constitutionally, and goes to show once again the value of body cameras. Deputy O'Hare asked for the passenger's identification. Deputy O'Hare noticed the presence of 3 cell phones for a car containing 2 people. He also observed the back seat of the rental car contained a lot of luggage. I would take note the idea of a person having 2, even 3 cell phones is not exactly unheard of, nor is someone traveling with a lot of luggage. I travel with a lot of luggage sometimes because I like driving. I don't particularly like flying. It's not that I'm afraid of flying, I just hate every part of it. So I drive a lot as a result. And so it's not unusual for my car to have a lot of luggage and wouldn't necessarily be unusual for me to have multiple cell phones. So I don't personally find that suspicious, but whatever. Rodriguez remained in the seat of the car while Deputy O'Hare returned to his patrol car to speak with the suspect. Deputy O'Hare asked further questions about the car, and the suspect clarified it was his girlfriend who signed the rental agreement because it was more cost-effective to rent the car to someone over the age of 25. In fact, many rental car places will not rent to you unless you're 25, but a few will, and they charge you an arm and a leg for it, but yeah. The suspect explained more of his travel details, and then Deputy O'Hare asked if he was transporting any weapons of mass destruction. What kind of a question is this? Are you transporting weapons of mass destruction? What's good? What? The suspect answered in the negative and said, no, you can do what you gotta do. He was asked if he was transporting any marijuana. He answered, no, you can go what you gotta do. Deputy O'Hare testified he understood his answers to mean that he was allowing the search of the car. Deputy O'Hare continued and asked about the presence of heroin, methamphetamine, and large amounts of cash. The suspect answered no to each, except he was carrying $300 in cash. Deputy O'Hare said, you say we can search the vehicle then? He responded, yeah, you can do what you gotta do. There's no reason. I'll have no reason to. Here is your legal pro tip. If the police are asking you a question, it's almost certainly because they have to ask the question. If the police can do stuff, they usually just do it. They don't ask. So if the police say something like, can we search your car? They're asking because they have to ask. I would strongly suggest you say, you may not search my car. And if they ask why, say, I don't want you to search my car. You don't have to explain beyond that. So just say, I don't want you to search my car. If they ask why, say, I don't want you to search my car. Be very polite about it. Say, you should probably say, officer, I don't want you to search my car. Officer, I just don't want you to search my car. That would be great. If you happen to know their name, that would be nice. If you can say officer what their name is, that'd be great. Otherwise, officer will do just fine. And, be polite and say, please, thank you, sir, would be fine. All these are good. But if they're asking a question like, can we search your vehicle? My response would be, no, officer, you may not search my vehicle. If they ask me why, I'd say, because, officer, I don't want you to search my vehicle. Now, if they then attempt to start searching my vehicle, I would not attempt to stop them, right? That's an issue for a suppression hearing at another day. But, I will not attempt to physically restrain them because they may have the right to search anyway. It may be that they were asking the question only as an additional safeguard. So my recommendation to myself and my recommendation to you is if you're ever in this situation, if they ask for permission, say no. If they give you an order, like get out of the car, give me your driver's license, put your hands up on the vehicle, etc. and so forth, follow the orders, do so slowly, say yes, no, sir, officer, these are all good things. And if they attempt to search your vehicle, even though you said no, allow them to search your vehicle. Do not interfere, but do not consent. And I'd recommend don't hand them the keys because that can be viewed as consent too. So don't say yes, don't hand them the keys. Feel free to unlock it, but otherwise I'd just not hand them the keys because that can be viewed as consent. And let them do what they're going to do and deal with the suppression issues later. There's your pro tip to the wise. Deputy O'Hare conducted a full search of the rental car, and in the trunk he found garbage bags containing 82 pounds of marijuana, and they're then arrested. 82 pounds of marijuana. That's a lot. Wow, good job. The suspect entered a plea of not guilty and later filed a motion to suppress. His motion asserted the officer lacked probable cause or reasonable suspicion for the stop, that the code section is unconstitutionally void for vagueness, his continued and prolonged detention violated federal and Iowa Constitution, and his consent was not voluntarily given. I can tell you right now, the code section is not unconstitutionally void for vagueness. That argument is not going to work, but nice try, but the rest of the arguments are at least plausible. Deputy O'Hare testified that it would take him probably anywhere from 10 to 25 minutes to commit a run-of-the-mill traffic stop. I don't know about you, but I have been in a traffic stop before, and 10 minutes is probably longer than any traffic stop I've ever been in. 20 to 25 minutes for a routine traffic stop seems pretty unheard of for a run-of-the-mill traffic stop. I don't know what kind of run-of-the-mill traffic stops you're doing, but like any traffic stop I've ever been in, if it took 10 minutes, that was the outside limit. So, like, that's a long amount of time. What are you doing? He further admitted throughout the duration of the traffic stop he never asked him any specific questions about the infraction. Deputy O'Hare admitted it was in his intention to investigate issues other than traffic infraction. He based this view on the fact that it was a rental vehicle, the 3 phones, luggage in the backseat, and becoming a third-party rental. In response to whether he ever entered the information onto the computer, Deputy O'Hare stated, "No, I never entered the information into a traffic citation." So the pretense is revealed. He never even entered the ticket into the computer. So it was never about the ticket. It was only a pretense for the stop. So, not something we've never heard of before, but yeah. So it was never about the traffic stop. It was all about the pretense. Okay. Maybe the officer got the idea for the first time ever from that woman, Sarah Harrington, during the Glover argument. Justice Kavanaugh did say it was Sarah Harrington's idea that we should do pretextual stops. So maybe he knew about the long history of Sarah Harrington, advocate for traffic stops everywhere, pretextual stops everywhere. Yeah, for those of you who don't know, I'm kidding. After the suppression hearing, the district court denied the motion to suppress. It determined the section was not vague and found reasonable and articulable suspicion existed the traffic law was violated. It also found the stopping deputy received valid consent to search the car. And we therefore grant the appeal. So the trial court found it to be proper, found the original stop to be proper, found consent to be proper, and admitted the evidence. And so the Iowa Supreme Court is granting discretionary review to review this case further. Let's see what the Iowa Supreme Court has to say. We first address the challenge to the scope and duration of the stop. Defendant argues the scope and duration of the stop were impermissibly extended by questions unrelated to the purpose of the underlying traffic infraction. Defendant contends any request for a consent search absent reasonable suspicion is in violation of the Iowa Constitution. We saw this argument recently also as it relates to, Washington or Oregon State, where we saw this exact same argument from them. So this is basically the same exact issue we saw before. In that case, that they're arguing it's a violation of the state constitution. Let's read on. Article 1, Section 8 of the state constitution guarantees the right to be secure against unreasonable searches and seizures and contains language nearly identical to the Fourth Amendment counterpart. In this case, we need not reach the challenge to the scope and duration of the stop based on the Iowa Constitution. Deputy O'Hare failed to obtain individualized suspicion of other criminal activity before unreasonably prolonging the stop. The unreasonable of the stop was in violation of the rights. So as I was alluding to earlier, you can't extend the time frame of the stop. In the Oregon-Washington case that we covered earlier, they also said under the state constitution, you couldn't extend the purpose of the stop. So here, defendant was arguing that you can't extend the purpose of the stop. But here they're saying we don't need to analyze the issue about whether or not we extend the purpose of the stop or not, because you extended the time. And that is unambiguously a violation of the Constitution. So we don't need to decide right now whether extending purpose is okay or not, because you extended the time improperly, and that was the violation. So improperly extending the duration, suppression. The detention of an individual during a traffic stop, even brief and for limited purpose, is a seizure within the meaning of the Fourth Amendment. This seizure, consistent with the Constitution, must be reasonable under the circumstances. We assume, without deciding, that failure to yield the left-hand lane, which is conduct prohibited by Iowa Code, provided probable cause to initiate the stop, and thus it was reasonable. Once lawfully stopped, inquiries reasonably related to the mission of addressing the traffic infraction and tending to related safety concerns are permissible. The reasonable investigation, however, may be expanded to satisfy suspicions of criminal activity unrelated to the traffic infraction based upon responses to reasonable inquiries. But the officer must identify specific and articulable facts which, when taken together with rational inferences from those facts, amount to reasonable suspicion that further investigation is warranted. Going back to our discussion from Glover versus Kansas, specific, articulable facts would be strongly helpful, yes. This is not to say law enforcement may prolong a stop indefinitely. They clearly may not. We determined individualized suspicion of criminal intent did not exist at the outset of the stop when the trooper first encountered the vehicle occupants. In a prior case, we had determined that individualized suspicion of criminal activity in that case did not exist at the outset of that stop when the trooper first encountered the vehicle's occupants. In the prior case, we concluded that 25-minute traffic stop was prolonged within the meaning of the United States Supreme Court case of Rodriguez. Our prior case reiterated the rules set forth in the United States case of Rodriguez. Authority for seizure ends when tasks tied to the traffic infraction are, or reasonably should have been, completed. So as they're citing the U.S. case of Rodriguez is the case exactly on point for this time extension principle. You can conduct a stop, and the stop should last as long as it needs to take, and as long as it should have reasonably taken. So when this officer said his typical traffic stop is 20-25 minutes, I don't think that's reasonable. I think 5 to 10 minutes probably is reasonable, but if you're extending the time unreasonably, you're in violation of the U.S. Supreme Court's case of Rodriguez. You can't do that. You cannot extend the time beyond that, which should take for the interaction. The defendant argues his stop was prolonged beyond what was reasonably necessary to resolve his traffic infraction, absent reasonable suspicion of other criminal activity. We conclude Deputy O'Hare failed to develop individualized suspicion of other criminal activity before unreasonably prolonging the stop. The same lack of reasonableness persisted after Deputy O'Hare initially conversed with the defendant. At the conclusion of the first conversation with the defendant, the only additional factor Deputy O'Hare developed as a possible red flag of other criminal activities was the odd travel plans. This factor, combined with previous factors, did not provide Deputy O'Hare with reasonable suspicion of other criminal activities. Personally, I don't find the travel plan that odd, all things considered, and certainly not enough to provide some reasonable suspicion that's articulable of criminal activity. Multiple cell phones is not illegal, nor is a lot of luggage illegal, and nor is I'm traveling to California to visit my girlfriend. Like, none of these, in my mind, create reasonable suspicion, nor do they in combination create reasonable suspicion. So the court would agree with me, or I agree with the court one way or the other, that this does not comprise reasonable suspicion. We cannot conclude Deputy O'Hare developed reasonable suspicion of other criminal activity after his first conversation with the defendant. Absent reasonable suspicion, after the defendant's first conversation, we must now determine whether the deputy unreasonably prolonged the stop. It is permissible for the deputy to make reasonable inquiries to address the traffic infraction and to attend to related safety concerns. However, absent reasonable suspicion of other criminal activity, the officer's mission is to address the traffic infraction, and the mission may take no longer than necessary. What becomes immediately apparent is Deputy O'Hare's complete lack of effort to address the defendant's specific traffic infraction. 6 minutes elapsed from the time the defendant entered the patrol car to the time the deputy departed to speak with his fellow deputy Lenz. Deputy O'Hare admitted that throughout the duration of the stop, he did not ask the defendant any questions regarding the traffic infraction. The body camera revealed Deputy O'Hare repeatedly thumbing through the rental agreement. There does not appear to have been any attempt to gain understanding of the document. To the contrary, the incessant page flipping appears to be a stalling tactic to keep the conversation going until a drug dog arrived. During this time, he did not attempt to run a check of the defendant's identifying documents or criminal history, and he did not prepare a traffic citation or warning. Deputy O'Hare admitted, "I was never enter the information into a traffic citation." Stalling for time on a pretense, not conducting the traffic stop he was alleging. He was on a hunt, and he unreasonably extended the time to engage in that hunt. That is improper under the United States Supreme Court case of Rodriguez, and thus this is all unadmissible. We conclude the constitutionally permitted stop became unlawful when it was unreasonably prolonged. For the aforementioned reasons, we reverse the district court's judgment as to whether the deputy developed reasonable suspicion of other criminal activity before unreasonably prolonging the stop. Because we reverse the district court's judgment denying the motion to suppress, we need not address other issues, reversed and remanded. So that is the Supreme Court case from the Supreme Court of Iowa in the state of Iowa versus Juan Salcedo. In this case, we learned that Juan was pulled over ostensibly for a traffic violation, going 60 in a 70-mile-an-hour zone in the left-handmost lane of Interstate 80. However, we learned that the officer really had no interest in the traffic stop. He was thumbing through the rental agreement, not in an attempt to understand its contents, but in an attempt to delay to get a drug dog to be present. And in doing so, he unreasonably extended the duration of the stop beyond what was needed in violation of the United States Supreme Court case of Rodriguez, which said specifically, you can't do that. So the obtaining of consent occurred after the time limit had already expired. He had already kept him way too long, and therefore the consent was null and void. Thus, 82 pounds of pot does not exist for the purposes of a criminal infraction. So this guy gets to live his life free and clear, and the 82 pounds of pot will not be used against him. Very sad for the state of Iowa, very sad for the police, but the police cannot break the law, and when they do, suppression is the remedy. So go forth, Juan, and sin no more. I somehow suspect that you may sin some more and probably won't get this lucky again from another court, but you know, you got a second bite for free, so you might want to take advantage of it, would be my recommendation. And until next time, my friends, that is all. I hope you're well. Until later, cheers and goodbye.